May it please the court, my name is Wright, initial M, and I appear for the accused, Simon, a 15-year-old Aboriginal boy charged with one count of murder. The defence applies under section 590, capital AA, subsection 2, paragraph E of the Criminal Code to exclude from evidence at trial confessionary statements made by my client during an interview at the police station. Your Honour, it is submitted that the Crown's evidence, whilst ostensibly admissible, be excluded on two grounds. Firstly, that the evidence of Simon's admission was obtained in contravention of multiple statutory requirements, thus contravening public policy. Secondly, due to the considerable prejudicial weight of the accused's confessions, which likely occurred due to gratuitous concurrence, admitting this evidence would be highly unfair to my client. Regarding the first ground, it is submitted that evidence tendered by the Crown be excluded from trial, consequent to the police officer's failure to comply with legal obligations pursuant to the Police Powers and Responsibilities Act, the PPRA. Section 418 states that a police officer must, before questioning a relevant person, inform them of their right to speak to a relative, friend, or lawyer, and must delay questioning until this has occurred. Section 421 relates to the questioning of a child, defined in Schedule 4 of the Youth Justices Act as a person under the age of 17 years. Despite not knowing his exact age, this section applies as the officer reasonably suspected that my client was a child. Your Honour, whilst this section strictly applies to children, I respectfully remind the court that my client is of an Aboriginal background. Section 420 applies when interviewing adult Aboriginal and Torres Strait Islanders. Here, the police officer has failed to provide my client the opportunity of access to a lawyer or legal aid representative. Furthermore, this section, in combination with Section 421, imposes an even greater duty on officers to observe the requirements of the PPRA. Pursuant to Section 421(2)(a), before questioning my client, the police officer should have also allowed him to speak to a support person chosen by the child and have allowed them to be present during the interview. While Simon's mother was present during the interview, he was not afforded an opportunity to speak with her before questioning. The Police Responsibilities Code, contained in the Police Powers and Responsibilities Regulations, sets out the particular responsibilities of police in these circumstances. Section 34 of the Code obliges an officer to make sure a support person understands their role before questioning begins. Your Honour, I submit to you that the officer in question did not comply with these regulations. My client's mother, being of the same cultural background as my client, and thus under a similar disadvantage, was therefore unsuitable to act as a support person pursuant to Section 428, subsection 3 of the Act. Further non-compliance of the officer's duties is demonstrated through the absence of any cautioning of my client in relation to his choice to speak freely or remain silent, pursuant to Section 431(1) of the PPRA and Section 26(1) of the Code. Finally, in relation to the initial detention period, the defence submits that Section 403(2) of the PPRA has been breached, as my client was held in police custody for a period of over 8 hours, without that detention period being extended. It is also possible that my client was questioned for more than 4 hours, in breach of Section 403(4)(a). Your Honour, given the breaches of the PPRA and the PPRR by the police officer in obtaining admissions from my client, public policy dictates that you have the discretion to have this evidence excluded. The circumstances here fall well short of the principles set out in Bunning and Cross to warrant exclusion of the evidence on public policy grounds. Here, the safeguards to protect the defendant were seemingly deliberately disregarded, or disregarded in a wholesale fashion. The conduct of the officer was not in response to any pressing circumstances. This non-compliance with statutory safeguards cannot be characterised as isolated, accidental, mistaken, or involving no overt defiance. Rather, it seems a calculated or reckless disregard of the law. Although the evidence is of a high cogency, its probative value is significantly diminished as a result of the multiple breaches of statute by the police officer. The ease with which the officer might have avoided these breaches and complied with the law in obtaining this evidence is stunning. While the offence of murder is the gravest on the books, to allow this evidence to be admitted would directly contradict the legislative intent in relation to the safeguards in place, which are purposeful and necessarily so. As such, The defence asks Your Honour to exercise the discretion to exclude this evidence on the basis that admission would be contrary to public policy. Regarding the second ground of our application, Your Honour, the defence submits that the evidence ought to be excluded pursuant to the Christie discretion, codified in Section 130 of the Evidence Act. Admitting such evidence would be unfair to my client. Following the cases of Lee and Hasler, exclusion under the Christie discretion can only occur when the evidence in question is of relatively slight probative value and there is substantial prejudicial effect. Here, the confessionary statements made by my client likely occurred due to gratuitous concurrence. As such, the confessions would be significantly more prejudicial than probative if admitted. Gratuitous concurrence refers to when an Indigenous person appears to agree to every proposition put to them, regardless of whether they understand the question. When being questioned by a person in authority, this is done to convey cooperation and avoid conflict when being intimidated. My client of Aboriginal descent was clearly intimidated by the officer's approach, resulting in him confessing to a murder that he did not commit. This admission, therefore, does not truly represent a confession of guilt, as the defendant did not understand the consequences of his answers. Your Honour, due to gratuitous concurrence occurring during questioning, the defence submits that my client's admission of guilt be excluded. In concluding, the Crown's evidence against my client was obtained through serious breaches of statute by the interviewing police officer, serving to undermine the law's purpose of providing justice and fairness. These breaches, in conjunction with gratuitous concurrence, are, as the defence humbly submits, sufficient to justify Your Honour exercising discretionary power to exclude the Crown's evidence in respect of my client's admission of guilt. Thank you, Your Honour. May it please the Court.